Welcome back to our special coverage. The judge at Donald Trump's hush money trial gave jurors extensive instructions before the opening statement started. Among them, that there is no formula for judging the accuracy of a witness, that they should use their, quote, varied life experiences in evaluating if a witness is credible, and that they can take brief notes, but the note-taking should not distract them from watching the proceeding. Joining us now is Alan Tuerkheimer. He's a jury consultant with some 20 years of experience doing juror research, focus groups, mock trials, and more to help legal teams prepare for trial. Alan, put these instructions into perspective for us. Is this typical, or is this something unique to this historic trial?
This is typical because this is such a new thing for these jurors to do, and they're laypersons. Now, yeah, there are a few lawyers on the case, but laypersons come into it pretty much with a blank slate. Now, they know about the former president, they know a little bit about the charges, and they were given opening statements. And now for the witness testimony, they are to pay attention, look at the witnesses, listen to what they say, take notes if they want, and then in their minds, they get to decide whether or not the witness was or was not credible. It's a pretty typical standard instruction that a judge would give jurors before the parade of witnesses start to tell the story for the parties in the case.
And Alan, give us your thoughts. How critical is the opening statement in the long run to the jury? Because we are weeks away from deliberation. How much will the 12 jurors remember of today?
They will remember a lot. So commitments that were made and the case narratives that were pointed out and presented, the jurors will remember that. Impressions of the parties and the case story start to form very early on in a case. And then as time goes by, as the evidence comes in and there are more witnesses, the preformed ideas that jurors have from opening statements then are interpreted and assimilated in their minds as the trial progresses. So it's really important that initial formation of the impression and the initial case story that jurors start to see. And that's why when you looked at the opening statements, clearly different case perspectives and case narratives, you want to have facts, you want to have arguments, but also jurors want a story. They want to know what really happened and what they're supposed to look for as the witnesses continue on with the cases as they unfold.
In his opening statement, Trump's lead attorney, Todd Blanche, said that Trump is, quote, a man, he's a husband, he's a father, he's a person just like you and just like me. What is he trying to accomplish here?
He wants jurors to see that this case is it's not about politics. It's not about a former president, that he's relatable, that he would do what you would do. The defense wants jurors to put themselves in the shoes of the president if they could possibly do that at that point in time, and then make decisions based on the best interests of their family. Now, whether or not it'll work, that's up for the jury. New Yorkers tend to have what I call good BS detectors. So whether it's the opening statement or the cascade of witnesses that are going to be testifying in court, it'll be up to the jury to decide whether or not the witnesses are truthful and are persuasive.
Todd Blanche also said this, and I'm quoting him now. He said, none of this is a crime, and that there is nothing wrong with trying to influence an election. It's called democracy, close quote. Two lawyers are impaneled on the jury. Why do you think both sides allowed attorneys to sit on the jury?
It's interesting, and maybe the attorneys thought the other side would use a strike on the lawyers, and they didn't. But I think the defense wants to shake things up in the deliberation, and it's certainly a wild card to have lawyers sitting as jurors on a case. They tend to argue and tend to take different perspectives. Lawyers are certainly good at taking two different sides of an argument, so maybe the defense thought that would be helpful. But at the end of the day, yes, they have law degrees, they're lawyers, and I think it's going to be a fascinating deliberation. A lot of times lawyers take a back seat and try to let the others speak in the deliberation. So I'm not convinced that they're going to dominate the deliberation, but they will certainly be a force when it comes time to decide whether or not the state proved its case beyond a reasonable doubt.
Yeah, important points. Alan Tuerkheimer, thank you very much for your expertise.
Thanks for having me, Wolf.